I'm Velden Gray, Director here at Velden-Duffey Attorneys, and with me today I have Wesley Keeney, who is going to give us some advice on illegal occupiers, getting rid of tenants that you no longer want in the premises, and things like that. Wesley, we received a very interesting question from one of our listeners. I'm going to read it to you so we can start the conversation from there. So the question reads, Sunny rented a house from Yanni. Sunny already paid the first month's rent and deposit. Yanni gave the keys to Sunny to move in, and Sunny now wants to make plans to move in. But the people that's currently living in the house, the previous tenants, they are refusing to move out and saying that they will continue to stay there because of squatters law. So tell me more about this squatters law, Wesley. What is squatters law?
The information given, it's obviously a little bit terse. It's a bit difficult. There's so many permutations in the law and changing circumstances. But effectively, I think what is being alluded to is the fact that in South Africa, every person has the right to adequate housing, and no person may be evicted without an order of court. So I think that's what they're referring to say that we have rights, that we cannot be evicted by you unless the court sanctions it.
Yes, that makes sense. That would be the squatter law that they would be referring to. That I'm allowed to live here for as long as I want, until you get a court order to say that you are allowed to actually evict me from the premises.
Yes, I would think so, yeah.
Okay, and what law governs this in South Africa? Because there's no Squatters Act or Squatters Law in South Africa. So what law governs this?
Well, again, there's no simple answer to the question because there's so many different circumstances and factors that apply. The most prevalent, the most common that we'll be dealing with, specifically from what I understand, this question would be residential housing. We'd be looking at what we call PIES, Prevention of Illegal Eviction Act. That's a short name for the act.
Okay, and what does the act provide for? Does it allow a landowner to evict people? What does it allow?
Yes, so it has changed the common law. Historically, in terms of common law, the landowner can evict. Now PIE regulates those rights. So any owner can evict people from their land, and also any person who constitutes a person in charge. Now, a person in charge is a person who has the right to give other people permission to occupy.
Okay, like an estate agent, for instance.
Well, yes, there could be, as an agent, that would be one, but you have instances, for instance, that even a tenant may sublet. That tenant who is subletting would be a person in charge because he got the right to sublet, and he would then, or he or she or whatever, would be able to evict the person to occupy in terms of the subletting agreement.
Okay, that makes sense. I also want to so squatter would refer to who?
Well, I think at its core, it's simply somebody who has got no right in law to be at the property, or whose historic right or any historic consent or permission has been withdrawn or terminated.
Okay, and then now I'm the landowner. These people are now refusing to vacate my premises. What am I supposed to do now? Can I just go in there with the trucks, load their things, and get them out? Obviously, that's not correct.
Definitely not.
Please don't do that, listeners and readers. Please don't do that. We've had circumstances like that, and it never ends well for the property owner. So, Wesley, what is the process? What do I then do?
Well, firstly, to do what you've suggested or inferred as a possibility is a criminal offence in terms of the PIE Act. So definitely don't do that. It's a criminal act. What you need to do is go see an attorney. That's always the first port of call because, again, there's so many potential nuances to any specific matter that an attorney would be best placed to advise you. But in general, what a landowner can do is the go see an attorney. The attorney will then proceed with the institution of legal proceedings in the appropriate court, the appropriate forum, to seek an order for the eviction of the squatters.
Okay, so that sounds like a lot of money and a lot of time. How long more or less would it take for you to get an order?
It obviously varies depending on the type of legislation which applies. I've only referred to PIE, but like I said, there's a number of nuances. Assuming that these set of facts we're dealing with PIE, if the matter is unopposed, meaning that they do not fight the matter, because there are certain procedural requirements that find application in terms of PIE, I would say on average, if it remains unopposed, about 3 months, give or take. The court has a discretion then over what period the unlawful occupiers have to vacate. So even though you get an order, let's say in month 3, it's conceivable that the court may say, well, the unlawful occupiers can only be evicted after a month or 2 or 3 months.
Okay, so to give them an opportunity to find alternative accommodation as well.
Yes, yeah.
Okay. Cost-wise, I'm not even going to ask the question because I know that differs from case to case, depending on the circumstances. So I'm not even going to go there. That you would probably, as an attorney, advise the client on when they do come and see you. Okay, but now what about, was it Sunny in the question?
Yes.
Sunny paid the deposit. Sunny is ready to move in. She already gave notice at her previous premises. What is Sunny's rights here? What is she supposed to do?
Unfortunately for her, she's in a very difficult position given the fact that Yanni, the landlord, will not be able to comply with his primary obligation, which is to give her occupation of the property. So first and foremost, in all likelihood, Yanni would be in breach of the lease agreement he concluded with Sunny. Sunny will not be able to take occupation immediately, as I've indicated, and in all likelihood, if they persist with their refusal to vacate the squatters, she will not be able to take occupation anytime soon. If it were a client of mine, I would ordinarily advise her to terminate the agreement, to try find somewhere else where she can live, obviously where she can take occupation, and then any money that she previously paid obviously would have to be repaid, given the fact that the landlord has breached the agreement from inception and has not been able to give her possession of the property.
Yeah. So if that owner now says, well, it's not my fault that these people don't want to move, I'm not going to pay you back, what's her rights then?
Well, she would have to then sue him, obviously. I mean, the fact that it's not his fault is irrelevant. I mean, he's not performing in terms of his agreement. And the underlying cause of the agreement now is also cannot be given into effect. So fairly simply, she would have to sue him if he were to refuse to repay the money. Apart from going to court, she could also, there are a number of other potential tribunals, like the rental housing tribunal that Sani could go to. I mean, depending on the amount that's been paid, the small claims court. But if it's a complex matter, I mean, you can always go see an attorney. But try the rental housing tribunals. They're actually designed to assist lay people without the use of an attorney. So the tribunal, the people comprised of the tribunal normally assist.
Yeah, my only finding with that, and I must honestly say I worked with the tribunals a long time ago, many years ago, but that they weren't properly functioning at that stage. And it's not a quick fix. It's not somewhere that you will go today, lay your complaint today, get your answer tomorrow and your order tomorrow. They only sit once every few months. There's a lot of other issues in that respect, and that's why people then rather approach attorneys. But thank you, Wesley, for your advice on this matter and the time that you spent with us today. I think what we can gather, listeners and readers, I think what we can gather from this is that there's many different facts which might be applicable to your circumstances and many different legal principles. It won't necessarily be the PI Act, which only deals with residential property. It might be farmland where other acts will be applicable, but that is all something that your attorney will be able to advise you on. Thank you for listening. Remember to click and subscribe, and we'll see you next time.